I want you to imagine a scenario right now. You are driving home from work, you stop at a red light, and suddenly bump.
Oh, the absolute worst feeling.
Right. You get into this minor fender bender with a delivery van, or, maybe it's a rideshare driver.
Yeah.
You pull over, you check the damage. It is literally just a scraped bumper.
Maybe you wake up the next morning with a slightly stiff neck, but nothing major.
Exactly. You exchange insurance info, you assume it's going to be a standard, boring insurance claim, and you just move on with your life. But imagine if, like, a year later, that tiny minor scrape has somehow morphed into $1 million federal racketeering lawsuit.
It's just a staggering escalation.
Ah.
We're used to minor traffic accidents remaining just that minor. But the legal landscape we are exploring today, it reveals how those incredibly commonplace accidents can be harvested as the raw material for something much, much bigger.
Welcome to this custom-tailored deep dive. We are unpacking a truly fascinating legal document today. It's a May 2026 memorandum from U.S. District Court Judge Kearney. And the core of this document is this massive clash between two giant transportation companies.
Right. Uber and FedEx.
Yeah, Uber and FedEx. And they are up against a Philadelphia personal injury law firm called Simon & Simon PC, along with this whole network of medical professionals. And Uber and FedEx aren't just fighting individual accident claims in state court anymore. They have gone nuclear.
Yeah, they really have.
They are utilizing RICO, the Racketeer Influenced and Corrupt Organizations Act, to sue the lawyers and the doctors for an alleged fraudulent scheme.
And to put that in context for you, RICO is the heavy legal artillery. It was famously designed to dismantle organized crime syndicates.
Like the mob.
Exactly, the mob. So seeing massive corporations turn a mob-busting statute on a local personal injury law firm and a group of local doctors, well, it tells you instantly how high the financial stakes have gotten right and just how aggressive the corporate defense strategy has become.
But before we get into all the wild details, we really need to set the stage very clearly for you. The source material we are looking at today contains allegations from a motion to dismiss.
That's a crucial point.
Yeah. This means we are discussing what Uber and FedEx are claiming happened. The goal of this deep dive isn't to declare anyone guilty or take a side. Our mission here is to examine the mechanics of this alleged scheme, understand how the legal system is allegedly being manipulated, and then look at the absolute wild card First Amendment defense the lawyers and doctors are using to try and get the case thrown out.
Right, because Uber and FedEx essentially hit a breaking point. They claimed they were bleeding money, paying lawyers to defend and settle lawsuits brought against them by this one local firm. And these suits were on behalf of people who suffered minimal or, sometimes no injuries at all.
Wow.
So they decided to map out the entire ecosystem of how these claims were being generated.
Okay, so let's look at that map. Because Uber and FedEx are alleging that there is this highly orchestrated system at play. The moment a client retains this law firm after a minor accident, a very rigid sequence of events allegedly kicks off. The memorandum actually describes it as a conveyor belt of pre-selected treatment providers.
A conveyor belt is the perfect term for what they're alleging. The initial phase begins with the chiropractors. The document specifically names Dr. Ethel Harvey and Dr. Daniel Pacillo at Philadelphia Spine Associates. The law firm allegedly directs its clients to these specific providers, totally regardless of the severity of the accident.
But, a chiropractor visit after a car accident seems pretty standard on the surface, right? People get whiplash.
They do, yeah. But the red flags emerge in the documentation of those visits. According to the allegations, these chiropractors were generating a massive volume of treatment records that relied heavily on cut-and-pasted boilerplate statements.
Oh, like a template?
Exactly. Uber found verbatim recitations of symptoms and treatments across entirely different patients' files. Furthermore, the source notes these instances where records were signed within minutes of a scheduled appointment time, even though the logged care would have taken much longer to actually perform.
Wait, really?
Yeah. And in some extreme cases, treatment records were allegedly created and signed before the appointment was even scheduled to occur.
Wait. Signing a medical record before the patient even walks in the door. That means the diagnosis is completely detached from the physical reality of the patient. The paperwork is driving the treatment, rather than the patient's actual condition dictating the paperwork.
That is the absolute crux of the allegation. The medical record wasn't a reflection of individualized care. It was a required piece of structural support for the next phase of the operation. So after building a foundation of chiropractic visits, the clients are sent for MRI scans at a specific facility.
And I'm assuming most of these MRIs for minor fender benders come back completely clean, right?
Many did, yeah. They came back negative, showing no traumatic or accident-related injury, maybe just the mild, normal, degenerative changes you see in any adult spine.
Right, just getting older.
Exactly.
Yeah.
But a negative scan did not halt the treatment plan. Instead, the strategy seemingly pivoted. If the scans don't show objective structural damage, the focus shifts to subjective pain. The clients were then pushed to a pain management specialist, Dr. Clifton Burt at Premier Pain and Rehab Center.
And this is where the medical intervention escalates dramatically, based on the memo. Dr. Burt wasn't just prescribing physical therapy or something. He was allegedly performing radiofrequency ablations on these clients. I looked this up in our notes, and it is highly invasive.
It is.
They use a needle to essentially heat up and burn away nerve tissue to stop pain signals. Sending someone to get their nerves burned away after a negative MRI and a minor bumper scrape feels like a massive leap.
It's a severe procedure. And Dr. Burt's records claimed he made the decision to perform these ablations based on his clinical observations of the patient's pain levels. But again, the allegations point to a paperwork trail that tells a completely contradictory story.
More templates.
Basically, his records allegedly used pre-typed statements, fill-in-the-blank fields, and identical language across multiple patients, all attributing the need for this invasive procedure directly to a motor vehicle accident. The timeline in his clinical observations allegedly often didn't even match the appointment data or, the underlying negative imaging.
That is wild. It's kind of like taking your car to the mechanic for a scratched bumper. The mechanic looks under the hood and finds absolutely nothing wrong with the engine, but they decide to replace the entire transmission anyway, just to generate a massive invoice.
That's a great analogy. And that brings us to the final destination on this alleged conveyor belt, the independent medical expert. So after the chiropractic care and the nerve-burning procedures, clients are sent to see Dr. Lance Yaris.
Okay, and what's his role?
His role is to perform a medical examination and write a comprehensive report projecting the client's future medical care needs and damages. And, get this, conveniently, his office is located in the exact same building as the Simon & Simon Law Firm's Philadelphia office.
Oh, wow. So the law firm just walks downstairs and hands Dr. Yaris this giant stack of pre-packaged medical records from the chiropractors and the pain doctor.
Essentially, yes. And based on that curated file, Dr. Yaris's reports allegedly confirmed serious, permanent injuries and recommended extensive lifelong medical care in 100% of the hundreds of cases he reviewed for the firm's clients.
100%. You mean to tell me, regardless of age, medical history, or whether the accident was a highway pileup or someone just tapping a bumper in a grocery store parking lot, 100%?
According to the complaint, yes.
This sounds less like a customized medical treatment plan and more like a pre-scripted reality TV show where the dramatic finale is decided before the cameras even roll. The ending, a diagnosis of permanent injury and lifelong care, is locked in, and the doctors are just playing their assigned roles to hit their marks.
And the mechanism that financially lubricates this entire operation is perhaps the most interesting part of the document. Normally, doctors bill health insurance, auto insurance, or the patients directly. But the law firm allegedly paid Dr. Burt and his clinic on a flat fee per procedure basis for those radiofrequency ablations.
Wait, really?
Yeah, and they didn't just write a direct check. They structured these payments through a third-party funder as purchases of receivables. The clinic didn't bill insurers for this work at all.
Buying receivables. Okay, let me puzzle that out for a second. Instead of the law firm directly paying the doctor for a medical service, which, by the way, looks an awful lot like the lawyer is employing the doctor to create evidence they use a third party to buy the debt of the medical bill, it turns a medical procedure into a financial asset.
You hit the nail on the head. Because the doctor bills auto insurance, those bills are subject to strict fee schedules, medical necessity audits, usual and customary rate scrutiny.
A lot of red tape.
Exactly. By structuring it as a purchase of receivables through a funder, it obscures the direct financial relationship. It masks the reality that the law firm is essentially financing the creation of its own legal evidence. Uber alleges this is the very definition of racketeering enterprise, an operation designed to manufacture a lucrative type of legal evidence under the guise of independent healthcare.
Which forces us to ask the ultimate why question here. Why go to all this trouble? Buying medical debt, coordinating nerve ablations, risking massive fraud allegations. What is the return on investment that makes this elaborate choreography worth it for the law firm?
The answer to that lies deeply embedded in the mechanics of Pennsylvania's auto insurance laws. Many of the clients involved in these accidents had what is known as limited tort motor vehicle insurance.
Right, limited tort. That's a trade-off. You pay lower monthly premiums for your car insurance, but in exchange, you surrender your right to sue for pain and suffering if you get into an accident. You can usually only recover your actual out-of-pocket medical expenses.
Spot on. Under normal circumstances, a limited tort client with a minor scrape and negative MRIs would receive a tiny settlement, if anything at all. In addition to that, the Philadelphia Court of Common Pleas has a rule. If a claim is under a certain dollar amount, it goes into a compulsory arbitration program.
Okay, what does that mean practically?
Well, arbitration is a lower-level, streamlined process that typically results in much smaller, conservative financial awards than a full jury trial.
Let me guess. There is a specific monetary threshold you need to hit to escape arbitration and get in front of a jury.
$50,000.
Hmm.
A claim needs to exceed that specific number to bypass the compulsory arbitration program.
So the $50,000 mark is like the VIP bouncer at a club. You need to show a big enough tab to get past him into the main room where the multi-million-dollar jury verdicts live. And limited tort clients with minor injuries just don't naturally have a $50,000 tab.
They do not. And this is why the conveyor belt becomes a structural necessity for the law firm's business model. The high volume of chiropractic visits creates the necessary baseline appearance of a persistent conservative care injury.
Right, building the file.
Yes, and that documented persistence then justifies the invasive radiofrequency ablations. Those ablations provide the severe medical foundation for Dr. Yaris to officially declare a serious impairment of body function.
Magic words.
Exactly. That specific medical phrase is the legal key that unlocks the limited tort restriction, allowing the client to suddenly sue for pain and suffering.
And because Dr. Yaris is recommending lifelong future care, the financial damages balloon instantly.
Precisely. The document highlights a crucial loophole here. Projected future expenses are not subject to the statutory limits that cap incurred medical costs.
Oh, wow.
Yeah. By adding artificially inflated lifetime damages estimates based on this choreographed medical history, the law firm effortlessly clears that $50,000 arbitration threshold. They basically convert a low-value, no-fault nuisance claim into a major litigation threat.
Okay, here's where I really want to push back, because I imagine some people listening might be thinking, isn't it a personal injury lawyer's literal job to relentlessly advocate for their client? Like, if I hire a lawyer, I want them to recommend aggressive specialists who will document my pain. I want them to utilize every legal loophole to get me the maximum payout so I am protected down the road. Where does standard, aggressive, sharp-elbowed legal advocacy end and a federal RICO enterprise begin?
And look, the defendants are absolutely making that exact argument. It's a fair question. But Uber, FedEx, and the judge's memorandum point to the extreme logistical control and the alleged falsification of records as the dividing line.
Okay.
Right. These lawyers weren't simply handing clients a list of recommended specialists. According to the complaint, the law firm was sending scheduling emails to the pain doctor, dictating the exact procedures he should perform before he had even laid eyes on the patients.
Wait, the lawyers were effectively practicing medicine? They were diagnosing the patients and prescribing the invasive ablations via email.
That's what the allegations suggest. They suggest the law firm was the operational brain of the entire medical pipeline. They sent the client's files in advance, told the doctor what procedures to bill for, arranged the transportation to ensure the clients actually showed up, and mandated that the clients jump on video calls with the law firm's staff immediately after the medical appointments.
That's intense.
It is. That level of orchestration, combined with the pre-signed records and the mathematical impossibility of a 100% permanent injury rate, pushes the behavior far beyond zealous advocacy. It becomes an alleged coordinated scheme to defraud Uber and FedEx into paying massive settlements just to avoid the catastrophic risk of a rigged multi-million-dollar trial.
Okay, so Uber and FedEx finally get tired of paying what they view as extortionate settlements, and they drop this massive RA lawsuit. But the defense strategy from the lawyers and doctors is absolutely fascinating. They don't just file a response saying, our medical records are perfectly accurate. They mount a massive constitutional defense to try and kill the lawsuit before it even gets off the ground.
Yeah, they deploy a very creative legal shield known as the Noerr-Pennington Doctrine.
I am somewhat familiar with this, but it usually applies to big corporate monopolies, right? Break down how it works in this context for us.
Sure. The Noerr-Pennington Doctrine does have its roots in antitrust law, specifically historical cases where railroad companies were lobbying the government to pass laws that would hurt the trucking industry.
Oh, right.
The Supreme Court ruled that you cannot use antitrust laws to punish someone for petitioning the government. It is rooted in the First Amendment's petition clause. Over time, courts have expanded this doctrine to recognize that filing a lawsuit is a form of petitioning the government for redress of grievances.
Well, that makes logical sense. If I sue my neighbor over a property dispute, he shouldn't be able to turn around and sue me simply for the act of filing the lawsuit. If you could be sued for suing, the courts would just grind to a halt out of fear of retaliation. We all have a First Amendment right to access the justice system.
Exactly, the protection ensures open access to the courts. The defendants, in this case the Simon & Simon lawyers and the medical providers, argue that their entire operation is immune from a RICO lawsuit. They are claiming, hey, everything we did was simply preparing to advocate for our injured clients in court. We were petitioning the government. You cannot use RICO to punish us for exercising our First Amendment rights.
Let me make sure I understand the absolute audacity of this argument.
Hmm.
They are essentially saying that because the allegedly fake medical records were destined to be used as evidence in a courtroom, the very act of faking them is protected free speech. That is like arguing that assembling a bomb in your basement is protected by the First Amendment just because you eventually plan to write a political manifesto on the side of it.
It's a bold stance. The defense is attempting to stretch the legal definition of what is considered incidental to a lawsuit. Courts have previously ruled that certain pre-litigation activities are protected by Noah Pennington because they are basically inseparable from the act of petitioning. A common example is a pre-suit demand letter.
Okay.
If a lawyer sends a letter threatening legal action and making aggressive claims, that letter is usually protected.
Because you can't have a functioning legal system without demand letters. They are a necessary precursor to the actual lawsuit.
Right. But the lawyers and doctors here are arguing that generating the medical records was done in anticipation of petitioning activity. They are claiming that because these documents were custom-built to be the foundation of a lawsuit, their creation is completely immune from legal scrutiny. Uber counters that extending First Amendment immunity to cover the actual manufacturing of false evidence distorts the doctrine beyond recognition.
I mean, if that defense actually worked, it would be a universal shield for pretrial fraud. You could forge any document, fabricate any physical evidence, bribe any witness so long as you did it before you officially filed the lawsuit. How did Judge Kearney untangle this constitutional knot in his ruling?
Judge Kearney denied the motion to dismiss. He refused to let the defendants hide behind the First Amendment, and to draw a clear boundary, he relied heavily on a recent precedent from a case called Montway LLC v. Navi Transport Services LLC, which was decided by Judge Bibas in the District of Delaware.
How did Judge Bibas draw the line in that Montway case?
He established a vital distinction between conduct that is directed at the government, such as filing a formal complaint or speaking in a courtroom, and communications with third parties that do not directly threaten litigation.
Ah, I see.
Yeah, and Judge Kearney applied that exact logic to the Simon & Simon operation. He pointed out that the lawyers directing medical providers to render unnecessary treatments and the behind-the-scenes collusion to generate false records, well, those were not communications directed to a court.
They were conspiring in private. Because they were colluding with third-party doctors rather than speaking directly to a judge or an opposing party, it just doesn't qualify as petitioning the government.
Exactly. Judge Kearney explicitly noted that if we deemed any conduct undertaken to generate evidence as incidental to petitioning, it would immunize almost any bad behavior imaginable, simply because a lawsuit eventually followed the fraud.
Did the defense have a backup argument? Like, even if the pre-litigation medical coordination wasn't protected, isn't the actual filing of the lawsuits against Uber still protected speech?
They argued exactly that. However, Judge Kearney brought up the sham litigation exception to the Noah Pennington doctrine.
So the First Amendment protection just evaporates if your lawsuit is a sham. But how do you prove a lawsuit is a sham before you even get to a trial?
You look at the pattern and the objective of the litigation. The sham exception applies when a party uses the governmental process itself. The sheer financial weight, the delays, the cost of discovery as a weapon to harass or extort a settlement, rather than genuinely seeking a victory based on the merit of the claims.
Right, weaponizing the process.
Exactly. When you look at the allegations of a 100% permanent injury rate across hundreds of cases, the pattern suggests the lawsuits were filed merely to grind the transportation companies down until they paid a ransom, just to make the litigation go away. Because of this, the judge is allowing Uber and FedEx to proceed to the discovery phase.
Which is huge.
Massive. They now have the power to subpoena emails, depose these doctors under oath, and basically attempt to prove this massive racketeering scheme.
We have waded deep into the weeds of federal court procedures, limited tort insurance thresholds, and constitutional loopholes today. But if you are listening to this on your commute or, while walking the dog, you might be wondering why you should personally care about a legal heavyweight bout between giant corporations and wealthy trial lawyers.
And that's the thing. The reality is that this affects you directly in your wallet. Uber's complaint specifically outlines how this alleged fraudulent scheme causes direct injury to their business. I mean, they are spending millions defending these purportedly fraudulent claims and paying out artificially inflated settlements. Those expenses are not simply absorbed by a corporate treasury.
No, operating costs always roll downhill.
They invariably trickle down to the consumer. It affects algorithm pricing, service fees, driver earnings. If a local law firm successfully manufactures million-dollar lawsuits out of minor fender benders, the cost of your daily rideshare, or the delivery fee for your groceries, well, it goes up to subsidize those legal settlements. Manufactured lawsuits act as a hidden tax on the entire transportation ecosystem.
Wow. Let's summarize the incredibly dense journey we've taken through this document today. We started with a minor scrape at a red light. We uncovered an alleged medical conveyor belt, this highly coordinated pipeline where lawyers dictated chiropractic care, ignored negative MRIs, ordered invasive nerve-burning ablations, and achieved a statistically impossible 100% permanent injury rate. We examined how they used financial vehicles, like purchasing receivables, to mask the money trail and bypass arbitration.
Right, and then we explored the really audacious attempt by those lawyers and doctors to shield themselves using the First Amendment, arguing that manufacturing medical records was a constitutionally protected precursor to a lawsuit.
And finally, we saw a federal judge draw a strict line in the sand, ruling that behind-the-scenes collusion with third parties is not protected free speech, opening the door for a massive corporate ICO counterstrike. It is a story that completely challenges the foundational integrity of the personal injury industry.
It absolutely does. And it leaves us with a really profound, forward-looking question about the future of our justice system.
What's the big takeaway for you?
Well, think about this. This alleged scheme required massive human coordination. Lawyers sending emails, doctors rubber-stamping boilerplate forms, staff managing client transport. But we are entering an era of generative AI.
Oh, man.
Yeah. If a manual paper-pushing operation can successfully engineer a 100% injury rate to extract millions from corporations, what happens when this entire pipeline is automated?
I don't even want to think about it.
When AI can instantly generate thousands of perfectly formatted, legally unassailable medical records and legal demands based on minor traffic data, will our courts even possess the capability to distinguish between a real human being suffering and an algorithm's perfectly optimized extortion?
That is a very chilling thought to mull over the next time you see a billboard for a personal injury lawyer, or the next time you hear about AI disrupting a traditional industry. Thanks for joining us on this deep dive.